Well, you know, so Franklin County is
Yeah.
is that.
That's, you need to have the other specific clarifier. Right.
High pitches.
All rise.
All right, good morning. Go ahead and have a seat. I think needs to get done. We can get to it. But I very much would expect you to raise those issues you think are necessary. So if the defense has motions, bring them on. If the state has motions, bring them on. I'll be doing the same. You already know that I'm not reactive. I'm proactive. I'm not dependent. I'm supposed to be independent. It's not about charm, because that's not part of the equation. It's about the job of the judge to get the trial done in a timely manner, in a fair fashion. So that's the goal, and I'll be proactive to do that, not to your exclusion. So we'll work our way through that as best possible. I've identified 3, maybe 4 topics for today. A conversational style will work, as long as we don't talk over each other or throw a stroke. Debates sometimes appropriate, sometimes not. So, in no particular order, there's a discussion and a motion by the state to amend the bill of particulars, so we'll want to talk about that. I'll have a question about election on firearm specifications and a discussion about motions to sever charges, and then I don't know what else the defense might have with regard to motions you think are coming. Same thing from the state, Ms. Canepa, so I don't know. My apologies, is it Miss Gall? Gall, thanks. So as counsel for the victims, I don't want to make you feel like you need to be outside the realm of the bar. So should we pull a chair up here for you?
Your Honor, I don't believe there's any victims' rights, concerns, or issues, so I'm fine to stay here unless you prefer that I sit at the table.
No, but like I don't always see the world as you might. So I don't want you to think that I don't care about victims' rights, but sometimes when I don't pay attention to the gallery, I won't know that there's a victim's right issue that you might want to assert that I didn't think of. So like your seating's fine with me, as long as you don't misunderstand, because yeah, that's important.
Duly noted, Your Honor, I'll stand and make myself known if something arises.
Okay, thank you very much. The state's got the pending motion to amend the bill of particulars. It's a well-drafted motion and pretty clear. Do you want to speak further to it, Ms. Canepa?
No, Your Honor, we just would respectfully request that the court grant that motion. As this court knows, it has the ability pursuant to Rule 7 to amend the indictment and or the bill of particulars at any time before, during, or even after. Certainly, you know, I have additional case law, State v. Martin, that talks about amending. That was a rape case where the conduct itself was different. It went from either fellatio to vaginal intercourse. I don't remember which one at this point, Your Honor, but suffice to say, completely different conduct. And the court ruled that it was permissible to amend the indictment to conform to the testimony that was provided at trial. So again, we provided notice to defense counsel. The point is well taken. They're not responsible necessarily to watch George's trial, but I know that they had been. But that aside, in August of 2023, we did provide them with the transcript, so they have had notice since that time. And specifically, as I pointed out in my motion, the address is the same, the location is the same. The only thing, there's a technical difference that is in Scioto County, but it's still the same address on Union Hill Road. They've got pictures of the inside and the outside of that location. there's no prejudice to the defendant. In fact, we're providing more specific information, just that property, the street in front of it is Pike County, but the property itself is Scioto. In fact, there's a point on the property where Scioto, Adams, and Pike converge. And this, part of this came from the Adams County Sheriff and the then Pike County Sheriff showing up to the crime scene, and they concluded amongst themselves that it was in Pike County. All to say, Your Honor, not all of the counts in the indictment happened in Pike County. The preamble to the indictment states that, as does the bill of particulars, that if it's not in Pike County, the defendant is properly placed in Pike because of the continued course of conduct in 2091.12. So again, there was notice to them that not all of these counts happened in Pike County, but that if they didn't, the state was arguing continuing course of conduct. They filed no motions on, to object to them being placed to the end of the year, when many of the other counts were clearly outside of Pike County. The Wagners lived in Adams County at the time, so the building of the silencer, the location of the evidence. They eventually lived in Scioto County. So Adams County and Scioto County were already implicated in this continuing course of conduct. There are some locations that we don't know, and we stated that too, because we just don't have that information. But, so again, I think they were already on notice that not all of the counts happened in Pike County. Our way of thinking is we're now providing them the more precise information, which again, and I feel like I brought this up before and said that I would be filing a formal motion, just to make the record clean for, like you said, years down the road when those of us present in the courtroom are home and gone, that it's clear that that actually happened. So, Your Honor, again, would respectfully request that the court permit this, additional notice of more precise as far as the county itself is located.
Thank you, Mr. Knapper. So who wants to speak on this?
Your Honor, I can speak on this. We appreciate the opportunity to reiterate some of the points that we found in our response. Primarily, this is a concern for timing. The state became aware of this specific fact during the trial that occurred in 2022, and this formal filing occurred here in 2025. We were set to start trial just a few days after. This was raised on the record at our last hearing, and then formally filed on the 10th of January. Criminal Rule 7 obviously provides a wide breadth of timing that the court can consider this amendment, Your Honor. But given all the circumstances of this case, how long ago these homicides happened, charges were filed, pleas were entered, trials were conducted, verdicts were rendered, Your Honor, this is a late in the game amendment request. Your Honor, for also due process reasons, what was presented to the grand jury information is also of some concern. For those reasons, what we raised in our response, we respectfully ask you to deny the motion. Thank you.
In street language, I would say, why does it matter? In lawyer language, I would say, what's the prejudice?
Your Honor, it's somewhat difficult to determine exactly what the prejudice would be given our concern of what was presented to the grand jury, what precise information was granted or presented. To your point, however, we have not filed a motion to contest the venue based on the location of the address at question here. However, this case has been going on for such a long period of time. This raises questions: what else hasn't been addressed? What other concerns are there out there that haven't been addressed leading up to trial?
The rhetorical question.
Yes.
Rhetorical question is whether you're entitled to a perfect trial or a fair trial. Like, don't answer that, because that's for me to work through. I understand what you're saying, but very much the legal standard is, why does it matter, i.e. what is the actual prejudice? I can't speculate about what may or may not yet be done, although I worry about that and I push ahead, and I'm trying to do that in this whole case. I can't do the abstract, I have to do the real. Okay, anything else?
No.
Mr. Hayes, looks like he's ready to jump in, or that's just twiddling with your glasses?
Just moving my glasses.
Okay. Any response to anything else, Ms. Canepa?
No, Your Honor.
So you get a written decision. The focus is going to have to be necessarily, why does it matter? I have to articulate the prejudice. Like, it's news to me that at different times, the Wagners lived in Adams County and then Scioto County also, correct? Is there any way of like tracking address times? Like, do you know when they lived at certain locations?
Well, I could get that for the court, Your Honor. I can't tell you off the top of my head, but at the time of the offenses, they were living in Adams County. At the time of their arrest, they were living in Scioto County. And evidence was retrieved from both counties. The forgeries, we believe, happened in Adams County, and I'd have to look at the indictment, but, there were times where we said, well, as we said, multiple locations, known and unknown, which are by some manner enumerated in 2901.112 of the Ohio Revised Code, whereby proper venue is placed in the county of Pike. So, that's throughout the indictment. In some of these where we didn't know, right? So we knew that they took property from Pike County, from the crime scenes, and they destroyed them in Adams County. But then they ultimately were recovered in Pike County at the Flying W, Billy's mom's house, things like that. So there were multiple counties that were involved in this. That's never been a secret. That's put in the bill of particulars and in the indictment. So again, I cannot imagine what they would do differently sitting here if the court were to allow the amendment. There'd be nothing they would do different going forward. Because again, it's the same location, it's the same address. Some things we knew with more specificity, others we just didn't even know where it happened, right? We knew they took it, but we didn't know where they destroyed it. We knew they, the prior calculation and design, which is an element of one of the offenses. Angela testified that Billy would come and pick up the boys and they would go off driving, and so again, Your Honor, I don't think they're harmed or prejudiced in any way. The argument is the same whether these 4 counts happened in Scioto County or whether they happened in Adams or Pike, because they already knew that there were multiple counties involved.
Okay. Anything else from the defense?
No, nothing there. Thank you.
I need to circle back on the last motion, which was the defense's request for clarification on other acts testimony. Like, we all know this, last month it's a bit more edgy for a lot of different reasons, but like, relevance is the first part of the analysis. Obviously, if it's not relevant evidence, then you don't even consider other acts because it has to somehow be related. Relevance is also thought of as what are the crimes alleged, i.e. what are the elements of the crimes alleged. So that makes me then go immediately to whether severance of charges is a part of the analysis. Like, I'm anticipating what's common and likely, I'm trying to get ahead of the curve here, is like, do I consider severance of charges? Let's just use your example, Ms. Canepa, forgery. If forgery happened in another county and severed out, just pick a reason, I don't care, it's not in, I'm not saying it would be. Well, then if forgery is not an element, we don't hear testimony about signing a document because it's got nothing to do with all the other offenses. Like, I just want to go back to law school. I might be talking to the audience now, not the lawyers. But in the consideration of other acts, am I also then supposed to consider severance of charges? Go ahead.
Yeah, we anticipated that we would be discussing that. We are looking at potentially trying to sever out several counts that don't fit into the state's theory of in theory of motives and things of that nature that may or may not be relevant. And Ms. Anstedt's been working on that, and so we were kind of looking at some of it, like you just said, the forgery, tampering, and things of that nature. So if we could have, prior to the next, status conference, we may have something filed for you on that. If we don't have a good faith basis, Your Honor, we're not gonna waste everyone's time, with that, but we are researching that based on what you indicated and based on what was provided to us with the May 30th date and that kind of agenda, so we are going down that list and looking to try to adjust those in advance.
Okay, so you just did two things. Used the word may and then walked it back, neither of which is wrong. But I'm not doing it that way, so I want your perspective, because we get into this tug of war at every court hearing, is who drives the bus, right? Is the court reactive or proactive? Well, we already know me. I'm pushing ahead for everything that needs to get done, so we don't get a decision from the Court of Appeals and then have to do more work. You asked me last time, when? And I said, short notice, because we ought to be ready on short notice. I don't have a schedule. It's too far out. There's too many moving parts. You've got more than one case. I've got more than one case. I don't know about Mr. O'Brien and Ms. Knapp, but we got to figure that out. But I'm going to push ahead. So you file your best theory on severance so the state can respond to it. The state can file a request to sever also,
Sure.
as much as the court can bring it forth on its own. So give me your thoughts so I don't have to guess. So I'm asking for it.
Because I'm at least kind of spearheading this.
Yeah, no, and I appreciate that.
What we're thinking, haven't formally
Yeah, that's
put
okay.
everything together. but
I'm not
we're-
committing you to anything. I just want to, I'm
Right.
already there, so you
Yeah.
might as well talk to me
What
while I'm
we're
there.
What we're considering is the tampering with evidence counts regarding phones, cameras, other items belonging to the victims, custody documents, those counts 15 and 16, forgery of the custody documents, count 18, unauthorized use of property, count 19, that's the social media accounts, and interception of communications, count 20. What we're starting from is the information we provided about Mr. Wagner's involvement within those specific counts, whether his specific conduct had anything to substantiate those particular counts. For example, with the custody documents, forgery of those, I believe at George's trial, and information we have in discovery, Angela, Jake, and George were and Rita were responsible for the conduct that constitutes that act. So, for example, we would consider requesting the court to sever that count from the trial. Also, with the social media accounts, unauthorized use of property, I don't believe that there have been allegations testified to at trial or in our discovery that Mr. Wagner logged into anybody's social media accounts or once in those accounts sent any messages surreptitiously. So that's sort of the theme that we're kind of working under right now. As to case law supporting that, as to statutory considerations, we need to beef those out, and we will in a formal motion. But that's generally where our thinking is.
15, 16, 17, 18, 19, 20.
Yes, Your Honor.
Yeah, thank you. I'm not going to put you on the spot, Ms. Knapp, I just need to know, I need everybody to know I'm already thinking about this. So when I suggest that you don't get maybe suggest something, it's because I'm already there. I'm not smart. I'm actually the least smart person in the room as a lawyer, but I have to get ahead of the game because it takes me longer to learn. So, thanks for the briefing. All the briefing in these motions has been well supported. It's very helpful. And then I look at that and I go get my own answer and I double check your sources and I sometimes find that there's a split. And then you have your theory of the case, she has her theory of the case, Mr. Bryan's got his theory. We all do, but we got to get it done. So that's why I'm asking for you to, and I may completely ignore it, I might drink it all, but I'm already there, so give me whatever your logic is in fairness to me, I didn't see Miss Gall until I found a notice of appearance and a notice of appeal from an interest that I never even knew was complaining. Like, nothing personal, welcome to the party, but I would have liked to have heard you tell me there was a concern before the notice of appeal. You don't have to do anything, nothing wrong happened, but every assignment of error starts out, the trial court erred. And the theory of the practice is we try to help the judge not err. So, like, that's why you don't get to show up sometimes. Your limited appearance was rejected. You're in because I don't want to have, like, an interest be asserted after it's too late for me to address it. Like, thanks for the advocacy. You're doing what you're supposed to do. Had the advocacy happened before the decision, we might not need to be on appeal. These lawyers up front, and Ms. Gall, have to do the same, protect me from myself. I don't intentionally err, but I do err. And your job is to make sure I don't, to the extent that you can. And, I don't expect the state to agree with the defense. Now we're talking philosophy here. I'll own my decisions after everybody hears what I need and tries to guide me through it. That's why you don't get a suggested motion. I'm telling you, brief it, because I don't want to go off on my own. And maybe you've done enough right now, Ms. Anstead, to tell me what your logic is. If you want to put it in a one-paragraph motion to make for a nice record, that's another way of doing it, but I wouldn't develop 30 pages of research. If you, it's your pleading to file, so I can't tell you what to do. I can simply tell you that I need to have this, because that's where I'm thinking. That's just me. Go ahead.
To answer your first question in general, I think there's going to be an ongoing struggle back and forth, a tug of war about trying to include Billy in the other acts that other family members did, that there's no evidence of support, that we're going to try to disassociate from that. So that's going to be a common theme with the other acts and with the settlements and things of that nature. So that's what's coming your way.
Yeah.
I don't think you disagree with that, right? Ms. Knuckles?
No.
That's going to be the.
I mean, obviously, I mean, the bill of particulars also indicates that he can be tried on complicity, right? And
Oh,
you
yeah,
have
I'm
to
not-
physically do it to be
In
a
terms
part
of
of
the
it.
conspiracy and in terms of that, that's going to
Yeah.
be the background.
The RICO broadens the thing a lot. The conspiracy broadens the case a lot, assuming they're there at the end. And I don't say that with any, like, glibness. No, it's all about what the charges are when we go to trial. Like, I gotta work my way through, because you want a solid answer on other acts. In fairness to me, in August, when I didn't make a thorough record, because I wanted to have a chance for the lawyers to get to know me, i.e., I want to know you, I don't think I said on the record, we're not spending 10 weeks on this case. Because I read through the record and saw a lot of evidence that had some relevance, but maybe not enough to warrant boring the jury. And Ms. Canepa said, no, this is a different case, or she would try it differently. Whatever your response was, you acknowledged that, because a lot of water had gone underneath the bridge from the first trial to when I got here last August. Yeah, like, we're all going to be looking for, strike that, I'll be looking for efficiencies. I don't know what you're looking for. So, like, very much so, we want to have, like, decisions that you can rely upon, some objectivity, not show up and throw something against the wall and see what sticks. Like, I don't do that, because I have to enforce my own rules. So I'm going to try to be as, like, objective as possible, so you can tell me I didn't follow my own guidance. Anybody else want to talk further about severance?
Your Honor, if I might.
Yeah, Mr. O'Brien.
Yes, Your Honor, I think maybe the best way to proceed on this and others is the court just set a deadline to file a motion, and we'll respond, and then the court can rule on it, and we'll all know where we're going.
Brilliant, if it was that easy.
But I don't know why it is.
No, it's not, because I can't let a deadline get in the way of due process.
At least on severance,
yeah.
Judge, I think from what Ms. Emily said, we could address that by actually file a motion in 2 weeks, we'll respond in 1 week, and we
Right.
can consider it the next status conference.
Yeah, the timeliness will be there. And honestly, like, I don't know what we're gonna do in February. I just marked you a date that I could call you on Wednesday before Friday saying, I don't see a reason to be here. To you, we'll consider the matter submitted on the pleadings. I just wanted to hold your life, not use it. So you don't book over the top of it.
No,
Like, I don't
that's
know,
exactly.
I don't know your schedule, Mr. Bryan. I know you're a good lawyer, an experienced lawyer. But like, I hear from the defense that they've got more than one case, and they got judges expecting them to be there. So like, me holding dates was to capture your attention, but maybe not actually use the time. So 2 weeks, Ms. Anstead?
Yes.
2 weeks after that is fine? Okay, so then we're there. And I don't like necessarily have to have oral argument, but now I want to go into like whatever motions you think you still might want to talk about.
Right.
Both
And the only
ways.
one the state has, I think, Your Honor, that we haven't filed yet would be a motion for jury review. And perhaps, as the court suggested, if the defense has other motions that they anticipate filing, that the court find out what kind of deadline may apply and then deal with it that way. As the court said, efficiency would work better if we could resolve all these beforehand.
Can you think of anything else? Like, I'm tracking that one because that's a part of,
Well, the change
My-
of venue implicates.
no,
the
you know,
jury.
I'm 3 months ahead of you. On
I
that
thought of it 3
issue,
months ago too, Judge.
you weren't here, I know, but I was. And as soon as, I can ask on my own motion to change venue. Like, I wasn't constrained by the prior judge's decision, never was, never will be, because the rules say on motion of the plaintiff, defendant, or the court, venue can be raised. I didn't do anything wrong to raise the issue. I'm gonna get stuck with how this flows, so therefore I'm proactive. Is that the third time I said that? Yes,
Okay,
that's
okay,
me.
and I understand that.
Yeah, it's not wrong, it's philosophical.
No.
The rule says I should do it. I thought of that as soon as I raised the issue. It's theoretical to raise the issue, it's practical where you're gonna go.
Right.
And I'm hunting, okay? Like, I got shoe leather invested in where this goes. Venue is on my mind in October
Right.
and September. Venue is on my mind in other cases that I've tried that they cited back to me like they should have, because I told them about it. I agree with you, but what else is there? Like, tell me whatever else you think I gotta look for, because venue's part of it, right? Oh, by the way, any place I move involves the sheriff, and the bailiffs, and the clerk of courts, and the jury commissioners. I get this.
No, and I think the
Yeah.
court's being proactive, so the only thing that we think is out there
venue?
for us is that jury review. And I don't know what else the defense
Okay.
may have, but if
Yeah.
the court suggest a deadline, then all parties will be ready to go when the appropriate times arises.
Wait till you read my current theory on jury review. But just make sure you're sitting down.
Well,
I've worked my way through it. I understand what you're saying. I sat over there for a lot of my career. 3 years over there, 14 years over there, 27 here. They're all different views.
that's right.
It's a hash. But in my mind, get ready.
Well, and that's why I raised it, so at least the defense does the same.
Yeah, I'm getting ready to go there and
All
ask
be on
them
the
what
same
they
page.
want.
Well, they
Yeah.
already did that motion for jury review.
That was in the county motions, I believe, so I
Yeah.
think those have been dismissed. But, you know, as any case, it's this old, our concern is the jury review is not reflective of how it was back on that date. And there's different buildings, there's different things, you know, some things have changed, and so anything you file will address and then go from there.
Yeah. What else do you think is coming at me with regard to your issues? I mean, you're right, Mr. Collins, I tossed all your motions, cleaning the deck. I'm cleared the deck, but that doesn't mean we're done, because we gotta get it right.
I think that as a group, we've talked about, Your Honor, the The only other potential thing that would become would be defects in the indictment with regards to the bill. Defects in the indictment we may have, and I apologize for using that. As a defense team, we've talked about filing some type of motion to dismiss certain things in the indictment as they reflect to the RICO or the conspiracy, things of that nature. So that's, as a group, when we left here last time, that's something that we're also going to investigate. That, in terms of procedural motions, that's probably the only one that I don't think we've talked about any of this in that.
Add one to your list. Add this to your list.
Okay.
Add this to your list. What did State versus Beatty do to the indictment? Beatty was a 24 decision that you can only impose 2 firearm specifications, right?
But that's,
I just have to eat that decision, apply it. I don't have any problems with the logic. It made sense to me. But does that then change the quality or the relevance of evidence? 6 times 2 is as bad as you can get.
No, exactly. And I think the state disagrees with you on that, or disagrees with that case, but
Oh, no, I get that. Totally. Why don't, maybe not. You don't have to agree with that. I think that's the law and you can do it as you want. But I
again,
think,
those are things, how they elect are things that potentially could go into that type of thing with the indictment. I understand what you're saying. And we're looking
Yeah.
at it.
I counted at one time, the current indictment has, how many is this, 79 verdict forms? Verdict forms. You take every spec under every charge, you get a verdict form on every spec. Right, now there's an instruction for every one of the 79 verdict forms, right? Like I've started jury instructions a long time ago. I can't tell you, well, I'm not up to triple digit pages yet. Oh, by the way, you're gonna ask X number of everyday ordinary people to come in and comprehend what you guys went to law school and practiced a long career to understand. My job is to fix that problem because we don't have a jury of lawyers, we have a jury of average people. So like consider what State versus Beatty did, if anything, and how that plays in the indictment, because you charged him before the Beatty came out. And I'll be looking for what's relevant. And if it's only a sentencing philosophy, then maybe it has nothing to do with it.
Understood?
Yeah, then you have the whole idea, I'm supposed to make it clear and fair, and how does that play out? So, worked on that one. Ms. Canepa? Anything?
no, Your Honor, I mean, we're familiar with the State v. Beatty.
Yeah.
I believe that's just a sentencing issue.
Yeah, but not everything's not just, because everything's all hooked together. I get what you're saying, I'm not asking for a commitment. This is where my brain has to run, so I don't get run over at the end of the case. Anything else on your list that you want to talk about? Any record you want to make?
No, Your Honor, we'll file our motion for jury review, and we'll respond to any motions that they will file.
Mr. Hayes, Mr. Collins?
Your Honor, a couple things. I think that the first thing is, that this is housekeeping. Billy is having a very difficult time hearing anything. It's not the volume, but it's the clarity. I've spoken to his mother, and we're trying to obtain a certain type of a clarification hearing aid, and I may need an order from the court allowing that into the facility where he is in custody right now and things of that nature, but I'm sure that I can make that happen. That's one of the things. But hearing in the courtroom, wherever we end up, is going to be a huge thing for Mr. Wagner. In terms of some counties have the headphones that amplify. The amplifier is no good for him. It has to be a clarification type situation. So that's just kind of a housekeeping matter to let the court know that I'll try to follow up with that with a court order and things of that nature for the February County Jail if they need that. The main thing, I think, and I'm not speaking for the prosecution, but we have not practiced in front of you in a trial. So anytime any of us go in front of you, the main thing to me is your voir dire process, and the logistics on there. And I've talked to Ms. Canepa about a concept that I've used several times in high media type cases, and where basically the questionnaire gets filled out, copies get returned to us, have them come in on a Thursday or Friday and fill out the questionnaire. We then take the copies at the end of the day, once they're made. Each side then comes up with a list of individual jurors that they would like to talk to, say Monday morning, for example. And the reason for the individual talk is because they've said something in their jury questionnaire that we don't want other jurors to hear or to poison the potential, things of that nature. So we would exchange probably, there might be 20 individuals that we need to talk to about, I apologize, let me back up. The first thing is we address, and I'm sure you've done this many times, commitments on time, babysitting, work, all that type of stuff. That will be done on that Thursday or Friday court date meeting with jurors. And then once they complete the questionnaires, we would then take them and submit the list to the court, a joint list that says, hey, we want to talk to these 30 individuals. And we would alternate doing individual voir dire and just about that concept only. So whether they know something in theory or whether how much media they've seen, but we're relegated only to that individual topic that we identified from the questionnaire. Basically what it does, Your Honor, is it gets all the cause bumps done in advance. So then let's say we have a final group of 60 people, then we're in no danger of running out of jurors potentially, to get the panel and the alternates. And then also, Judge, and maybe we can put this in writing, but your policy on bumping, excusing jurors, whether it's in front of the people, how you move them in the box and things of that nature. So I think that would be helpful to all of us, just so that we can feel more comfortable and be more efficient during that process.
I think my current case management order is 21 paragraphs. That isn't enough, but I'm trying to anticipate how we're going to do this, what it works out to be. So, because everything you're talking about is exactly right. Like, I know how I'm going to try this case, but that doesn't help anybody. We're past the point of being able to delay. I'll get increasingly more assertive. Good luck with that. I'll tell you exactly where to stand and where you don't have to stand, so you don't have to guess. I want the jury to understand we've tried a dozen cases together last year, which means you understand me well enough and I understand your expectations. Like, I think of this courtroom as a theater, and you ought to be able to use the theater of persuasion to do the law. So I'm not going to anchor you to a podium. That's just me. That's how I wanted to try a case. Till you mess with the court, and then I'll figure out how to deal with you. Till you cross a line that you know you shouldn't have crossed, then I'll deal with you. Like, it's your case to try, but we have to try it right. That's the fairness aspect of the court's duty. So yeah, like, I don't have a problem with sometimes asking you to argue your objection in front of the jury, because then it makes more sense to them. So if it's an easy hearsay objection, I'll say, what's that mean? And then Mr. Collins will explain, and then Ms. Canepa will explain. The jury will go, oh, now we get it. The whole process of a trial is not just about facts, it's about educating them to do it right. Everything you're saying is exactly right. To circle back on specifics, your 8-page suggested questionnaire is about 4 right now. Okay? Like, I'll hear you out after I show it to you, and you say, I left some stuff out, and I'll say, yeah, you're right. But I don't expect to give the jury, prospective jurors, 8 pages, right? I've talked to some really nice clerks of court and jury commissioners who have told me how they want to do it, right? I'm juggling that ball. I don't know where we're going, I just know what the options are. And then I have to account for how they do their system, very much how they do their system. So, like, everything you're saying, I appreciate, because when I give you short notice, you're going to wish you knew all this stuff ahead of time. And I don't know what short notice is. Like, I totally don't. Mr. Hayes, something else?
Just trying to figure, I mean, we talk about the notices with the court as far as where we're gonna go forward, and we're kind of just held like in abeyance right now, depending on the Court of Appeals, and whether there's anything after that Court of Appeals. From a logistics standpoint, and I know everybody has a lot of things going on, and everything's a little bit on hold. We have a heavy trial schedule. Also have some family, vacation in March that's somewhat on hold. I'm gone 2 weeks in May. So I'm just not sure what we want to look for. If we want to look at dates as a potential trial, or like my concern is, I know this court wants to go forward. I know even over all of other cases, this is going to be a priority one, and we understand that. But we're just trying to juggle a lot of logistics, and everything's kind of placed on hold a little bit, just with our practice, and especially if we're in a different community and I'm living in a different town for, the first trial was roughly 4 months. We don't envision anything that's going to be during that length of time, but there's a lot of logistics that go into that. So, and I'm not sure if the court can even get any definition, but we've been kind of on hold for a week in March, and kind of 2 graduations that I'm contending with in May. So just trying to figure some logistics, but I'm not sure if we can have any of that definition right now, because we're on hold, but I just want to bring that up.
Yeah.
Where we,
But that's fair to you and me, and my docket, and your docket, the state's docket, right? Like, I know when I am booked out for 2 weeks at a time, repeatedly, right? So, like, I'm gonna try to not ruin your personal life. But like, you gave up that when you took the oath of office as a member of the bar, right?
Sure.
Well,
this has a priority, and I understand that, but
Yeah.
I'm just also trying to.
Yeah, no, I don't wanna like have you miss like your family graduation. I don't know what I'm gonna do, I just don't wanna have to say,
Fair.
like I didn't consider it. I don't know. I totally don't know. Like, this is just me thinking out loud. We're either in limbo or purgatory, depending on whether you think we're getting punished. But we're definitely in a hold, right? And then when we get out of limbo, then we have the adult conversation of like, okay, how's this gonna play out? Like I told you last month, I'm gonna go to bat for you when you say I can't be there because you have other clients that have high needs and other judges with high expectations, and I'm pretty sure that applies to the state. Everybody's supposed to be somewhere else.
Well, we understand. and
Yeah,
this would have-
I'll try to work it, I get it. I won't just like throw dates on the board saying be there. Till I have to. Right?
Fair enough.
Yeah, but you get this, everybody, we have to talk. Like, we're looking for the point of least resistance. Judge Corbin had the right idea. The fixed solid trial date. I mean, to the extent that you could say that he did, and he should have. Okay, what else you got? That's perfectly good.
Your Honor, just, you provided on January 14th a judgment entry with things to think about. So I took the initiative and met with our client and went over each of those. And so for his sake, as well as the court's, as a group, we do not have any competency issues right now at this point in time with our client. I don't know if that's what you were indicating with regards to our client versus potential witnesses. I don't know of any potential witness competency issues. In terms of discovery compliance, the government has been very helpful with us. We may need help with where things are and things of that nature because of the logging system. I think technology used during the trial will take care of itself. With stipulations, Your Honor, we would like to try to get those from the government as soon as possible because that will help us in terms of that and concepts. We've already talked about the effects of indictment. We're fine with remote witness appearance as long as it's not Angela or Jake. We're not going to object to anything other than that. The only defense experts we would have is depending on mitigation or not, Your Honor. We have gone over the ability of waiver of trial by jury. At this point in time, Your Honor, we would still elect to have the jury process. I'm going to speak with him about that each time we meet with him, and if that changes, we will let you know. And then we defer to the court with regards to media access and limitations and expectations. Same with item J, Your Honor. And I think we've already talked about L, jury selection. So those are the things that we've talked about with both our client and as a group, Your Honor, for the court's knowledge.
Okay, thank you for running down the punch list. Ms. Cadepa, any discussion about the punch list?
Just regarding the stipulations, Your Honor, I think it would be most beneficial and productive for us to sit down and discuss that as opposed to me just being like, here's a bunch of stipulations that you may or may not have even, versus we come to an agreement about generally what we would stipulate about, and then I'd be happy to come up with the stipulations themselves.
Anything else? Thank you for that.
No, yeah.
Mr. Wagner, first of all, I was not aware of a hearing issue, and I'm glad your lawyers raised it.
It's not really a big issue, Your Honor, I'm legally dead.
In one ear, the other ear is good.
Have you ever, one ear is done, the other ear is not very good.
How much of today do you think you heard?
Not much.
Okay, I gotta know this.
Yeah, not much.
I gotta know this.
Yeah,
I have to know this. So, anytime you have a problem, I have to know this. Your lawyers are right to say you're gonna look at some sort of hearing assistance device. But I have to know this. So it's not rude. Anytime you don't hear, it's necessary for you to tell me there's an issue.
well,
All right? So tell me anytime there's a problem. Understand? It's called accommodation. It's called like fundamental fairness. We say due process. I gotta fix it, whatever that means. Right? So that's first cousin to competence. Like I've been watching you, not staring you down, but necessarily, like everybody in the room, I'm doing the survey. I have to like be responsible for the fight that I don't see coming in the corner. I have to pay attention to you just because it's a part of my job. So far, you've been well-mannered, appropriate, attentive, so thank you for that. A lot of defendants can't do any of those. Understand? You're well-mannered, you're acting appropriate. You're well-mannered, it's a good thing, understand?
well, most time in here, Your Honor, y'all might as well be speaking Cantonese or Mandarin, because I don't catch it.
Yeah, well, when we go law nerd on you, like we did today,
Huh?
when we talk like lawyers and
That's right.
technicians, yeah, like half the people in the room might not understand the words, although I think a lot of this was common language. We have to make sure we explain things, and your lawyers have to tear it down and build it up again. So I'm assuming they go back and explain and answer your questions, right?
Yeah.
Like, are you satisfied with your lawyers?
Huh?
Are you satisfied with your lawyers?
Yeah.
Like, I think they're doing a fine job, but it's not my lawyer, it's yours,
Yeah.
okay? Like, if there's ever a lawyer problem, tell me that also. I don't see it, but I need to know if you have an opinion to the contrary.
No,
Like, I haven't tried a case with any of these lawyers. I know Mr. O'Brien because you can't not know him. I know the reputation of your lawyers is good, so that's a good start, but it's your case, your opinion is important. So you have to tell me if there's a lawyer problem, all right? Same way I need to know if you can't hear. In my former courthouse, every time the fire department made a run, we just stopped, because the echo was insurmountable. This courtroom's better than that one. So it works. But if there's an issue, I gotta own it, deal with it, fix it. All right? Now, here's the next thing, and then I think we're done. I don't get involved immediately in plea negotiations. I don't have an opinion whether there should be one. I brought it up in August because it's on my list of duty. My job is to make sure that box gets checked. There's no obligation on you or the state to enter a plea negotiation. So I don't have a preconceived notion about how this is going to end. I know if I don't talk about it, I didn't check the box of being thorough. Understand? Yes?
Yeah, yeah.
Okay. So that's a part of it. How the lawyers want to set the case up is up to them. Here's where that changes. Lawyers negotiate thinking that that's the outcome, when in fact, at some point in time, they have to bounce that negotiation off the person who doesn't have to accept it. Were you involved here about the sentencing 3 weeks ago? Do you know what happened to your wife and son?
No. Oh, yeah, yeah.
Do you know what the sentences were?
Huh?
Do you know what the sentences were?
You know what they.
Yeah, they told me what they told me.
Okay. Like, I don't, that's all you do is need to know.
Yeah, I know they, yeah,
Yeah, it's called context.
yeah.
Doesn't mean that's what's gonna happen to you. It's just knowledge. It's context. You understand that?
Yeah, I understand that.
So like, if the lawyers want to negotiate something, that's fine. If they want to bring it to me, they need to, because my job is not to sign off blindly on what other people think I ought to do, because judges are independent. Now, I understand Ms. Canepa didn't have a mutually recommended sentence imposed. That's how it works. Nothing went wrong. That's how it works. So if you want to negotiate, that's fine. If that happens, they know to talk to me. Understand? Do you understand?
Your Honor, you know, I understand that perfectly, and they've explained that to me fine, but,
Yeah.
Yeah, they've related to me. Yeah, I'm good.
And so the record's clear, Your Honor. Anytime we have something that we believe is going to happen in the next month or the next quarter, we go in advance and explain it to Billy so that he can process it. It's
Yeah.
not a volume thing, it's a processing thing. And Lieutenant Carver has been nice enough to give me information so that the hearing aid issue will happen rather quickly, so I appreciate that, Your Honor. And so the only issues we have are friction in terms of our ethical, what I believe our ethical duties are with regards to negotiations versus what Mr. Wagner wants. So that's the only time that there's friction, just to let the court know.
Yeah, fair enough. I don't have any input in the negotiation. I get the outcome. Okay. Anything else you want to talk about, Mr. Collins?
No, Your Honor.
Mr. Hayes?
No.
Ms. Anstead? Ms. Knapp, anything?
I have a question for the court.
Yeah.
That I think would be beneficial for all of us to know. I fully understand that the court has previously told us on the record in chambers and, you know, through conduct, I guess, that we can negotiate agreements or pleas or whatever. This court obviously is going to independently evaluate that and make its own arrive at its own conclusion. Does this court, say for instance, they say, oh yeah, well, he's willing to do this, and we're like, well, that's great, we agree, whatever. Does this court would this court let the council know if you were inclined to go along with it or not? If it so deeply offended you that you would not, or do you simply don't do that and we all find out at sentencing time? Do you know what I'm saying?
I'm going to answer that.
Okay.
Okay. Do you have anything else, Mr. O'Brien?
No, Your Honor.
Ms. Gull, do you have anything you want to bring up?
No, Your Honor.
Okay. So here's the honest answer. I don't know who's safe. And you don't know if I'm safe. And that's the way it's supposed to be. It's not fault. We don't have familiarity. You can call every defense lawyer that practiced in front of me and get their opinion. And you can call every prosecutor and get their opinion and sift it as best you can. But when it comes down to SAFE, every case is like a new experience. So I haven't like ambushed anybody. I've signaled, whispered, and nodded, and talked on the record and explained philosophy, but never made a commitment because you can't. Like, I think you're all safe to talk to until your words don't match your actions, which is why I gave you the question last month, rhetorically, am I supposed to believe what lawyers tell me? I don't really want an answer. I don't think anybody did anything wrong. I think the circumstances got to the point where nobody could deliver on what they were saying. I'm good with that. That's how difficult cases are. So if you have a proposal, then we have to decide if we put it on the record, if we go back and huddle up in chambers, because most of my colleagues would say when you talk in chambers, all you ever do is get thrown under the bus. And those discussions are helpful until the judge gets thrown under the bus. I didn't pre-decide anything. I talked about philosophy. I talked about how I look at the world. That's just meant to give you some idea. So then you decide if you have a plea negotiation where we do it, and I still won't commit to it. But I won't let the court system, the judge, get thrown under the bus for trying to accommodate lawyers. Ain't gonna happen. I had found no lawyer to be disrespectful at any point in this trial, this process. I have colleagues who have different opinions about what they would have allowed in their presence. That's okay. I don't care about their perspective because they aren't responsible for the outcome. So we're good. Like, I'll tell you, you know me well enough, I'm gonna lay it at you, not circle around behind you. And then you can just deal with it. But like I said earlier, every assignment of error starts out the trial court error. It's not my goal to get out of bed and make mistakes that day, but I do. So you keep me out of trouble. We'll try to make a better experience for the public and the defendant and the victims, and we'll get a fair outcome, whatever that means. I got no opinion on trials, please. I'm playing this out the way we have to get it done right. So, yeah, I want to hear if you have negotiation. We just have to figure out what is safe in doing it. And I have a legal duty to not just sign off blindly when I check my brain at the door. Good point. Anything else? All right, Mr. Wagner, thank you very much for your attendance. Thank you to the court staff and security folks and the transport. Off the record, please.
Thank you, Your Honor.
I don't know, I'm not reading. I wonder if anybody's
Is that speed okay, or is that driving pace?